sir.
Your Honor,
the document.
we can't proceed.
The document.
We can't proceed without jurisdiction.
All right, I have an idea, sir.
Can you hear me now?
Yes, now we can hear you. Very good. All right, state your name for the record.
My name is Fernando Gonzalez, living man.
Very good. And we already have an appearance of Mr. Duffield.
The exact same name.
In regard to the matter for motion to dismiss, Mr. Gonzalez.
Whoa, right off the bat. Fernando's trying the classic corporate fiction trick, claiming he's representing a legal entity spelled in all caps, not himself. This is textbook sovereign citizen territory. Judges despise this because it's basically a legal dodge to avoid responsibility. Audience, have you ever seen someone try this in real life? Drop your wildest courtroom dodge stories in the chat.
Or fiction, the all caps name.
You cannot do that. You cannot represent a party other than yourself, sir.
Well, then we got a problem.
You and I both know that. So, proceeding as Fernando Gonzalez, do you wish to address your motion for? Do you wish to address your motion for dismissal? Objection.
He's labeling me a driver when he has no proof that I was transporting goods, services, or passengers for hire.
Your objection's overruled, please.
Now, this is where it gets a little wild. Fernando objects to being called a driver, arguing he wasn't paid for transportation. So technically, he's traveling, not driving. It's a semantic loophole to avoid traffic violations. But here's the kicker. Does this argument hold any water legally? Spoiler, nope. Driving laws are about safety, not paychecks. What do you think? Clever, wordplay, or just grasping at straws?
We're on Zoom. Please identify them and point out the things that they were.
Fernando Gonzalez on the Zoom screen.
Mr. Gonzalez, thank you for turning your camera on. If you don't wish to keep it on, that's fine. I don't have a problem with that, but I usually like to be looking at the person I'm dealing with in court, but I do need you to take your hat off because we are in court.
I'll take my hat off for $500.
Well, then you can either take your hat off or be held in contempt of court, or you can turn your camera off. One or the other.
I'll turn my camera off. I don't like being told what to do. Get this far without establishing jurisdiction.
Jurisdiction is established by the Michigan Constitution, and
did you get the paperwork?
Duly recognized court of the state. I've already ruled on that motion, sir. If you wish to address it on appeal, you're welcome to do so. We do have a jurisdiction. Any further questions of this witness? Of this witness, do you have any questions of the witness?
Of this witness? No, I don't think I do. Other than who's the injured party here? I mean, I would like to cross-examine the injured party, not the police.
This moment is pure gold. The judge orders Fernando to take off his hat standard courtroom decorum, and Fernando, deadpan, demands $500 to comply. Then he'd rather shut off his camera than follow a basic court rule. That's next-level defiance. Right there. Can you imagine how judges react internally when defendants play these games? This is the I do what I want energy, and it's simultaneously hilarious and cringeworthy.
You wish to sum up any arguments you have?
I object.
Mr. Duffield.
You're not letting me proceed. You're not letting me defend myself.
Sir, you're not proceeding. You keep saying you want a motion for dismissal, but I've already directed that that is denied.
But I asked you, did you read the FOIA request that I just sent you a while back?
Sir, no, I did not read a FOIA request because I haven't received one. So I can tell you, and not only that, that would be irrelevant to this proceeding.
How would you know without reading it first?
Anything further?
How would you know without reading it first?
Because a FOIA request in regard to this matter, we are talking about a motion, a trial for driving with a license suspended. Do you have anything pertinent to that in regard to this trial?
Yeah, the FOIA request that I sent you. Pretty much
anything other than that, sir. I am deeming that to be irrelevant. You can take that up on appeal as well. You can take that up on appeal as well. Well,
See,
sir, we're on trial. You don't file things a moment before a trial and then expect the court to receive it. First of all, we didn't receive it. But in any event, sir, I've already
Well,
made my ruling. Do you
I
have,
never
sir?
can-
I'm not going to argue with you. The
I
matter is
never,
that is disposed of. You can address it on
that's
appeal.
why we're here
Anything-
today, is to argue.
Sir,
Now, listen to me.
sir, you can
Your
address
Honor.
it on appeal.
Your
You can
Honor,
address it on appeal, sir.
you want to get out of this so bad, you don't even want to fight with me on this, or what? You're
I
just
don't
gonna
want to fight
ignore
with
me?
you at all because that's nonsense. I don't want to fight with you. I have nothing against you, sir. I'm just asking you to proceed with pertinent information.
Brace yourself. This is where the judge's patience officially snaps. Fernando keeps cycling through the same jurisdiction and irrelevant document defenses like a broken record. The judge tries to explain, but Fernando pushes back with the classic, "How do you know if you don't read it?" line. It's like arguing with a wall, and you can almost hear the mental steam coming off the bench. Ever been in a conversation like that? Tell me your never-ending argument. Stories?
Well, that's
With 72
nonsense,
hours,
and,
You,
so that is,
There's nothing to
you've
base
known this
that on
case
other
has
than
been
your-
pending. This case has actually been pending since 2022.
that's not my fault.
Here,
I
well,
rescinded
that
that
is
ticket
indeed
in
your,
72 hours.
in any
So
event.
your guys'
I do find that the
fault for-
people have proven their case
Honor-
beyond a reasonable doubt. I do find that he's guilty in this matter. Fines are $250, state costs $50, court costs $200, crime victim right fee of $75.
You don't have my consent on any of this.
And $150 in bench warrant fees.
And I want my bail back too.
That would be then a total of $725, and I'll give you 90 days to take care of that.
That's
Is there
not gonna
bond?
happen.
Is there actually bond that's been posted? We have $300 bond. We'll apply a bond,
I object to that.
and we're applying it.
For a victim,
And boom, the verdict drops. Guilty, fines, fees, the whole shebang totaling $725. But Fernando's not done. He calls it a victimless crime and refuses to consent. This is where sovereign citizens usually dig in their heels hardest, rejecting the system outright. The fascinating part. Even when courts lay down the law, some folks would rather fight reality than accept defeat. What would you do in Fernando's shoes? Take the deal or keep fighting?
We're on Zoom. Please identify them and point out
Yes.
something that they were.
Fernando Gonzalez on the Zoom screen.
Mr. Gonzalez, thank you for turning your camera on. If you don't wish to keep it on, that's fine. I don't have a problem with that, but I usually like to be looking at the person I'm dealing with in court, but I do need you to take your hat off because we are in court.
I'll take my hat off for $500.
Well, then
We're-
you can either take your hat off or be held in contempt of court, or you can turn your camera off, one or the other.
I'll turn my camera off. I don't like being told what to do.
Final thought. $725 in fines for what Fernando calls a victimless crime. But from a legal standpoint, driving with a suspended license is about protecting public safety, not punishing harm after the fact. This clash between personal belief and legal reality is at the heart of many courtroom standoffs. So, audience-aware, do you draw the line between standing your ground and respecting the system? Drop your thoughts below.